In narrative films, ultimately in all narrative films, you have trademarks that appear on products or in narrative films under two things. Product placement, where a brand pays for their logo on a product to be placed in a film, or product integration, where your Hydro Flask is incorporated into the narrative of the film. So like the your trademark good is part of the narrative. Okay, so it's either just included on the set or it's included into the narrative. Now, and there's obviously money that's exchanged for that. Now, you can't just include this on your film set. This would be a trademark violation if I just had this here, or this logo, or the logo of the greatest basketball team ever in the history of basketball, right? You can't just have that stuff appear on your set. It all has to be cleared in a narrative film, a fiction film. Okay. But if you're depicting reality, this stuff can appear sometimes. As long as you're not exploiting the trademark. An example here is of George of the Jungle 2, which is a Disney movie. Disney got sued by Caterpillar. As George is trying to protect the jungle from being bulldozed, the bulldozers are Caterpillar bulldozers. Well, Caterpillar sued Disney for this. Number one, they thought why didn't they Greek it out, blur it out? Why did it also associated the brand with deforestation? But when you often see excavators, bulldozers, they are Caterpillar brand. In some of the film sequences, you see the Caterpillar logo on the bulldozers, not in an exploitative fashion, not in a close-up, etc., etc. The court ruled in favor of Disney, which basically says that you can have logos appear in narrative films that are not cleared as long as those are on products that are part of a depiction of reality. And the reality of destroying the Amazon jungle or any jungle involves Caterpillar bulldozers. Let's watch this clip. This is from the movie Seven from 1997. I want us to watch it and tell me why, or try to figure out why New Line Cinemas would be sued by Sandoval for this. So let's watch this.
Everybody stay outside.
Usually when I ask students to identify what's the issue here, they'll say the pill bottles, the Bible, etc., etc. This is a scene where Brad Pitt and Morgan Freeman's characters, find the murderer's lair, house. And what actually was the issue here was Jorge Antonio Sandoval had photographs that were used. They were out of focus, they were in the background, they were not, but they were used on the film set. Anytime copyright or trademark, artwork or logo appears on a film set, it has to be cleared if it's exploitative. And that's a really important part of it. If I had a piece of art, on my film set and it's very apparent, you can see the artwork, it adds to the film set itself, it's a painting or whatever, a sculpture, you'd have to clear the rights for that. My friend worked for Time Warner, and she worked for their publishing department, And one of the things that she cleared was all of the books on the set of Seinfeld and Jerry Seinfeld's apartment. You rarely ever see them at all, but they cleared all that. Okay, so anything you have on a film set has to be cleared if it's readily visible and adds to the aesthetic and you can see it. So Jorge Sandoval thought that his photographs, were exploited on this film set, sued New Line Cinemas. Okay, it includes 11 shots that amount to about 35 and a half seconds of the scene. They are all out of focus and in the backdrop. Well, the judge ruled in favor of New Line Cinema and basically said that their use was minimal. This is something called de minimis, which means, not of legal concern. The use was so minimal that it does not warrant infringement, does not warrant, it's not of legal concern, okay? And they said the use was fair. We'll talk more about de minimis in the coming weeks, which is one of your defenses you have if you use someone else's work. And it's, a minimal use, not a lot of time, not very visible, not exploitative, not derivative, okay? Now, if these images were in focus, or like you see an over the shoulder shot and they're holding the image and you can see the image, that would need to be cleared because that's exploitative and that's derivative. Here's another example. So you'll be able to see this. We have a charcoal drawing by Lebbeus Woods and neo-mechanical tower upper chamber. This was actually used for the basis of the opening scene of Terry Gilliam. Terry Gilliam, who infringed on the graffiti artists, Jazz and Ever in Argentina, used Lebbeus Woods' drawing as the basis for the design of the opening scene of 12 Monkeys. You can see both these images side by side. It's a pencil drawing. Now, Lebbeus Woods, ahead of the release of the movie, set forth a lawsuit and filed an injunction. An injunction basically means, and I think I talked about this talking about The Hangover 2 and The Tattoo Artist, was that you cannot show the work or display the work in any way, distribute the work in any way, until the legal matter is cleared up. So for a film company who spends a lot of time promoting and marketing a film for a specific release date, this is a major issue. So they ended up basically settling out of court, which basically said that, Universal Studios / Terry Gilliam's use of Lebbeus Woods' drawing for the basis of a set design would be infringement, and they knew that. So if you use someone's art as the basis to design a film set from, you need to license that. It's considered a derivative use. Here's a more recent instance. This is Lena Iris, who's an African artist, versus Kendrick Lamar. You can see a little bit of her art and her style, which is like this black and gold style. This was used by Kendrick Lamar for his music video, All of the Stars, I believe, from the Black Panther soundtrack with SZA. And, Victor, Lena Iris Victor sued Kendrick, Top Dog, SZA, for using her art as the basis of their set design for this music video. And basically she says that they copied the style and the motifs and used it in the artwork. The interesting thing is that Marvel had reached out to her because they wanted to use some of her art as the basis of set designs for the movie Black Panther. She said no, which is pretty interesting. So the fact that Top Dog, Kendrick would use it, for the set design of the music video is also quite interesting. Kendrick claimed that his use was fair. Now, I'm a huge Kendrick Lamar fan. You want to say, yeah, your use was fair, but it's not. And he also said that it didn't cause her any financial harm, which it probably didn't. But it doesn't matter because it's not a fair use, because it's not building upon or commenting on. It's fully exploiting her work. But the interesting thing was that she doesn't register a copyright on her. She doesn't have a registration on her copyright for the works, so she could only seek actual damages, which is actual harm, which is pretty interesting because, as we know, that's the actual financial harm that's caused to you versus $150,000 per infringement, which really adds up fast. She may be able, she's pretty prolific and pretty well known. She could have maybe even gone into VARA, because it's mutilating the intent of the artwork. But she didn't. They ended up settling out of court, which means clearly they infringed on her work. That's been undisclosed, and that was in December of 2018 that they settled.